So I have heard some unusual demands in my courtroom. I have heard people request new judges, new hearings, new evidence, new witnesses, and even entirely new laws because they did not like the ones already in place. But I will never forget the woman who walked into small claims court and demanded a jury trial as if she were starring in a television drama. And believe me, the way that moment ended still makes people laugh when they talk about it. Her name was Karen Whitfield. The moment she entered my courtroom, I knew she was not there to solve a problem. She was there to win a performance. Years on the bench teach you to recognize the difference. People seeking justice focus on facts. People seeking attention focus on the audience. Karen focused on the audience. She wore a bright white blazer, oversized sunglasses resting on top of perfectly styled blonde hair, and carried a thick leather folder under her arm. Before she even reached her table, she glanced toward the gallery twice, not because she knew anyone there, because she wanted to be seen. Across from her stood Robert Hayes, a 62-year-old retired mechanic. His hands were rough. His suit did not fit perfectly, and he looked deeply uncomfortable. That mattered, because Robert looked exactly like the kind of man who would rather fix an engine than stand in front of strangers discussing a dispute. The case itself appeared simple. Robert claimed Karen had hired him to restore a vintage motorcycle engine and then refused to pay the final balance after the work was completed. Karen claimed Robert had overcharged her and performed unauthorized repairs. On paper, it looked ordinary. But experience has taught me that the most chaotic cases often begin looking ordinary. I asked Robert to explain the agreement. He carefully produced invoices, photographs, text messages, and signed work orders. Everything was organized in a neat folder. Karen immediately rolled her eyes. That told me something. People who have strong evidence usually attack evidence. People who do not have strong evidence often attack the person holding it. Then Robert explained that Karen approved every repair in writing. Karen laughed, not nervously, not awkwardly, confidently, like she had been waiting for her moment. I asked her, "Is something funny?" She smiled. "Yes, Your Honor." The courtroom became quiet. "Would you like to explain?" Karen stood up slowly, dramatically. She straightened her blazer, placed both hands on the table, and looked around the room before speaking. I noticed something then. She wasn't looking at me. She was looking at the gallery. That is always dangerous, because once someone starts performing for spectators, facts become secondary. Then she said the sentence that changed everything. I refused to proceed without a jury. The courtroom froze. Even Robert blinked. For a second, I wondered if I had misunderstood her. "A jury?" I asked. "Yes," Karen said confidently. "I demand a jury trial." A murmur spread through the gallery. Karen seemed pleased by it, very pleased. That reaction told me she believed she had just discovered a secret legal weapon. But years on the bench teach you another truth. People who are absolutely certain they understand the law are often seconds away from proving they do not. I calmly explained, "Mrs. Whitfield, this is small claims court." Karen nodded. "I know. You understand there are no juries in this proceeding." Her smile widened. Then she opened her folder and pulled out a printed document. I researched my constitutional rights. The gallery shifted. Robert lowered his head, and I immediately knew this hearing was about to become far more complicated than a motorcycle repair bill, because Karen had arrived with legal theories. And she clearly believed she was about to teach the courtroom something. What she did not know was that the next 60 seconds were about to destroy her entire strategy. Karen Whitfield stood there with that printed document in her hand like it was a winning lottery ticket. I have seen that look before. It usually appears when someone has spent one night online and walked into court, believing they have discovered a legal secret every judge somehow forgot. Karen lifted the paper and said, "The Seventh Amendment guarantees my right to a jury trial." The gallery went quiet again. Robert Hayes looked at me, then back at Karen, confused but patient. He was not a man looking for drama. He had brought receipts, photographs, and work orders. Karen had brought a constitutional argument to a small claims repair dispute. That contrast mattered. I said, "Mrs. Whitfield, this court is not conducting a jury trial." She smiled. "Then you're violating my rights." There it was, the first accusation. Not misunderstanding, not a question, an accusation. People like Karen often use legal language as a shield, but also as a weapon. They do not ask the court to clarify. They accuse the court of corruption before the law is even explained. I looked at her calmly and said, "Small claims procedures are designed for simplified civil disputes. You chose this forum when you filed your response and counterclaim." Karen's smile flickered. Only slightly, but I saw it. Because she had not expected procedure. She had expected applause. She said I did not waive my rights. I replied, "You are free to pursue claims in the proper venue if the law allows it, but you do not get to transform this courtroom into a jury trial because the evidence is becoming uncomfortable." That sentence landed. The gallery reacted softly. Karen's face tightened. Robert's attorney then stood and explained that Karen had been notified 3 times in writing of the small claims process. She had also signed a mediation refusal form and checked the box confirming she understood the hearing would be decided by the court. Karen interrupted. "I signed under pressure. I asked, 'Who pressured you?'" She paused. That pause mattered. "A real accusation usually has a name, a date, a detail. Karen had none. She said the system." Robert looked down at his folder. I could see fatigue in his face, not anger. Fatigue, and I began to understand that this demand for a jury was not about constitutional principle. It was about delay. Robert had completed the work months earlier. Karen had refused payment. Then she disputed the invoice. Then she threatened reviews. Then she demanded mediation. Then she refused mediation. Now, when the case finally reached the hearing, she demanded a jury. Every step moved the finish line. That is a pattern. I asked Robert how long he had been waiting for payment. He said, 7 months, Your Honor. 7 months. For a retired mechanic living on fixed income, that is not just inconvenience. That is pressure, Karen said. He should have thought of that before overcharging me. Robert lifted his head for the first time with real pain in his eyes. "I charged what you approved," he said. Civil words, steady voice, no performance. Karen rolled her eyes. And that small gesture turned the courtroom further against her. Then Robert submitted the signed work order. Karen's signature appeared beside each additional repair. New carburetor cleaning, electrical rewiring, replacement gasket. Fuel line correction. Each item approved, each cost listed. I asked Karen, "Is this your signature?" She said, "Yes, but that doesn't mean I understood it." That answer revealed the next problem. Karen wanted authority when giving instructions, but helplessness when facing the bill. And before I could ask another question, Robert quietly opened one more folder and said, "Your Honor, I also have the messages where she asked me to add the work." Karen's eyes snapped toward him. The paper in her hand suddenly lowered, and the courtroom knew exactly why she had wanted a jury, because she did not want the judge reading those messages. When Robert Hayes said he had the messages, Karen Whitfield's confidence changed immediately. Not disappeared, changed. That is important. Some people collapse when evidence appears. Karen did not collapse. She recalculated. Her eyes moved from Robert's folder to my bench, then toward the gallery, then back to the printed constitutional page still in her hand. She was looking for her next escape route. That is what delay tactics often are. IACSA routes dressed as principles. I asked Robert to submit the messages. Karen stood again. "I object." I looked at her calmly. "On what grounds?" She paused, then said, "Because I requested a jury." A few people in the gallery shifted, not laughter exactly. More like disbelief, trying to stay polite. I said, "Your request has been denied. Sit down." For the first time that morning, Karen looked truly offended. Not legally harmed. Not confused. Offended that the courtroom had not rearranged itself around her demand. She sat, but her face hardened. Robert handed over the printed messages. I read them slowly. Karen had written, "Go ahead and replace whatever needs replacing. I want it running perfectly." Then another message. "I don't care what it costs as long as it starts on the first try." And another, "Add the electrical work too. I want this done before the charity ride." I looked up. "Mrs. Whitfield, these messages show you approved the additional repairs." She leaned forward. "That is not consent to be exploited." Again, the language shifted. Not denial. Reframing. Manipulative people often do that when facts trap them. They stop arguing what happened and start arguing how everyone should feel about what happened. Robert quietly said, "I told her the price each time." He handed over more messages. There they were. Exact estimates, exact replies. Karen had responded with thumbs-up emojis. "Fine, and just finish it." The gallery grew still, because sometimes evidence does not need drama. It simply stacks up until the lie has no room left to stand. I asked Karen, "Did you send these responses?" She said, "My phone sends emojis automatically sometimes." That was the first moment the courtroom almost broke. A low ripple moved through the room. I raised one hand and restored order, but even I had to pause before continuing. Not because the answer was funny, though it was absurd. Because it told me Karen would rather insult the intelligence of the entire courtroom than admit a simple fact. Robert looked wounded now, not angry. Wounded? He said, "Your Honor, I worked late nights to get that engine ready." She told me it was for a memorial charity ride for her brother. Karen looked away. That detail mattered, because emotional urgency had been used to pressure him. Robert explained that he moved other jobs back because Karen said the motorcycle needed to be ready for an event honoring her late brother. He said he felt bad for her. He wanted to help. Then, after the work was completed, Karen refused to pay and claimed he had taken advantage of grief. I watched Karen while Robert spoke. No tears, no sadness, no visible grief. Only irritation. That does not prove grief was false. But it told me something about how she used it in that room. She did not seem hurt that Robert mentioned her brother. She seemed angry that he mentioned the reason he helped her. Then Robert submitted one final screenshot. A message from Karen sent after he requested payment. It read, "Good luck collecting. I know how court works better than you do." The room went silent. Karen's printed constitutional page suddenly looked very different, not like research. Like part of the plan. I looked at Karen and asked, "Did you come here intending to delay this case?" She opened her mouth, but before she could answer, Robert's attorney placed a small flash drive on the table, and Karen's face went pale, because the messages were damaging. The video was worse. When Robert's attorney placed that flash drive on the table, Karen Whitfield stopped moving. That was the first honest thing her body had done all morning. Until then, she had been all gestures and performance. The printed constitutional page, the raised chin, the dramatic objections, the demand for a jury like she was standing in a federal courtroom instead of a small claims hearing over a motorcycle repair bill. But the flash drive changed her because paper can be argued. Masks can be twisted. Video is harder to bully. I allowed the footage. The screen turned on and a small repair shop appeared. Fluorescent lights. Toolboxes. A red vintage motorcycle resting on a lift. Robert stood beside it in an oil-stained work shirt, holding a clipboard. Then Karen appeared in the frame, not confused, not pressured, not grieving, confident. She walked around the motorcycle, pointed at the engine and said, "I want everything fixed. I don't care if it costs more. Just make it look like I knew what I was doing when I bought it." A murmur moved through the gallery. Robert looked down. Karen stared at the screen with her jaw tight. The footage continued. Robert said, "The electrical work will add to the bill." Karen answered, "Fine." He said, "The fuel line needs correction too." Karen said, "Fine." Then Robert asked, "Do you want me to write all of this on the work order?" Karen laughed and said, "Write whatever you need. I'm not going to fight you over money." That sentence sat in the air like a stone because that was exactly what she had done. Fought him over money, denied him for 7 months, dragged him into court, then demanded a jury as if procedure could erase a promise. I asked Karen, "Is that you on the video?" She said yes, but he recorded me without explaining every detail. I looked at the screen. Mrs. Whitfield, the video shows him explaining the details. She said nothing. Then the video continued to the moment that changed the entire room. Karen leaned closer to the motorcycle and said, "If this thing runs well, I can probably sell it for double." Robert turned toward her. "I thought this was for a memorial charity ride." Karen waved her hand. "Maybe, maybe not. Depends what it's worth after you fix it." The courtroom went cold. Robert closed his eyes. And I understood why. He had worked late nights because he believed he was helping someone honor a dead brother. Whether that brother existed or not was not the issue in that moment. The issue was that Karen had used emotion as leverage. She had made his compassion part of the transaction. That is a kind of manipulation many people underestimate. It is not always loud. Sometimes it sounds like a sad story told at exactly the right time to make someone give more than they agreed to give. Karen had wanted extra work. Robert had done it. Then she had tried to make him pay for his own kindness. The attorney paused the video. The gallery was silent. I asked Karen, "Did you tell Mr. Hayes this motorcycle was for a charity ride?" She said, "It was discussed." Again, fog. Not yes, not no. Fogg Robert's attorney then submitted event records from the charity ride Karen had mentioned. Her name was not listed. The motorcycle was not registered. The organization had no record of her participation. Karen snapped, "That doesn't mean anything." But it did. It meant the emotional emergency she used to rush the work had no support. It meant Robert's late nights were built on a story she could not prove. Then the attorney said, "Your Honor, there is one more clip from the day she picked up the motorcycle." Karen whispered, "No." It was quiet, almost involuntary. And that whisper told me the next clip was the one she feared most. The screen changed. Karen stood in the repair shop, smiling beside the motorcycle as it started on the first try. She turned to Robert and said, "Perfect. Now let's see if I can get out of paying full price." And then she laughed. That laugh changed everything, not because it was loud, because it was honest. Karen Whitfield had spent the entire morning pretending she was a confused customer, a grieving sister, a citizen defending constitutional rights, and a woman being denied fairness in small claims court. But on that repair shop video, standing beside a motorcycle that started perfectly, she exposed herself with one sentence. "Now, let's see if I can get out of paying full price." The courtroom reacted instantly. A few people gasped. Someone whispered, "Unbelievable." Robert Hayes looked at the screen like he was watching the exact moment his trust had been turned into a joke. And Karen? Karen did not look sorry. She looked furious that the video existed. That is a difference I have seen too many times. Regret looks inward. Exposure looks outward. Karen turned toward Robert and said, "You had no right to record that." Robert answered quietly, "It's my shop." The simplicity of that answer almost ended the argument by itself. Then Karen tried to grab back control. She stood, lifted the printed constitutional page again, and said, "This is exactly why I demanded a jury." A judge can be influenced by edited clips. I looked at her and said, "Mrs. Whitfield, the full clip is playing." The screen continued. Robert asked in the video, "What do you mean, get out of paying full price?" Karen smiled and said, "Everyone negotiates after the work is done. Don't be dramatic." Then she patted the motorcycle seat and added, "Besides, small claims is cheaper than paying people who overcharge." The courtroom went completely silent. There it was, the plan. Not a misunderstanding, not sticker shock, not unauthorized repairs, a strategy to use court as a discount tool. Robert's attorney paused the video, but the damage was already complete. Karen had demanded a jury, not because she believed justice required it, but because she wanted another delay, another performance, another chance to intimidate a man who had done the work she requested. I looked at Karen. "You used this court as leverage." She snapped. "I used my rights." "No," I said. "You used legal language to avoid responsibility." That sentence landed heavily. Karen's face reddened. Then came the viral moment everyone remembered. She slammed the paper onto the table and said, "Then I demand a jury again." The gallery froze. I leaned forward and said, "Denied." She said, "I object. Overruled. I appeal. You may follow proper procedure after judgment. This is unconstitutional. This is small claims court." That exchange lasted only seconds, but the room reacted like it had been waiting for someone to cut through the fog. Karen opened her mouth again, but I stopped her. Mrs. Whitfield, repeating legal words does not create legal grounds. And for the first time all morning, she had no answer ready. The paper that had once looked like a weapon now lay flat on the table, useless against her own recorded words. Robert wiped one hand across his face. His eyes were wet, though he tried to hide it. I understood why. He was not simply hearing that he might win. He was hearing that he had not been foolish for trusting her. That matters. Manipulators leave people questioning their own judgment. They turn kindness into embarrassment. They make honest people feel stupid for believing them. But the evidence had restored the truth. Then Robert's attorney submitted one final exhibit, an online listing posted 2 days after pickup. Karen had listed the motorcycle for sale. The description read, "Professionally restored. Starts perfectly. No issues." The asking price was almost double what she owed Robert. The courtroom erupted again. Karen stared at the listing. And then I asked the only question left. "Mrs. Whitfield, if the repairs were defective, why did you advertise the motorcycle as perfect?" Her mouth opened, closed, opened again. Nothing came out. And that silence was the first truthful testimony she had given all day. There are moments when a courtroom does not need another argument. It needs a ruling. Karen Whitfield sat with her printed constitutional page flattened on the table in front of her. The same page she had waved like a weapon now looked small beside the evidence. The signed work orders, the text messages, the shop footage, the pickup video, the sales listing, every piece told the same story. Robert Hayes had done the work. Karen had approved it. The motorcycle ran exactly as promised, and Karen had tried to turn small claims court into a stage for avoiding a bill. I dismissed Karen's claim in full. Then I ruled in Robert's favor for the unpaid balance, court costs, and documented losses caused by Karen's delay. I also made it clear on the record that her repeated demand for a jury did not create a right where this proceeding did not provide one. Karen looked at me and said, "So this court just ignores the Constitution?" I looked back at her calmly. "No, Mrs. Whitfield. This court applies the law. That is exactly what happened today." For once, she did not laugh. Robert lowered his head, and I saw the relief move across his face. It was quiet, but it was real. He had spent 7 months waiting to be paid for honest work. 7 months being made to feel like the villain for asking for what he was owed. That is the part people often forget. Money disputes are rarely only about money. They are about dignity. They are about trust. They are about whether a person can do honest work and still believe the system will protect them when someone tries to twist kindness into weakness. As Karen gathered her papers, she did not look defeated by the law. She looked offended by accountability. That is different. Some people learn from losing. Others only resent the fact that consequences found them. Robert picked up his folder slowly. Before leaving, he looked at the screen one last time where the motorcycle listing had been shown. Then he looked at Karen, but he said nothing. He did not need to. The record had spoken for him, and that is why this case stayed with me. Not because Karen demanded a jury. People misunderstand legal rights every day. It stayed with me because she believed legal words could replace honesty. She believed procedure could be used as a hiding place. She believed if she sounded confident enough, the truth would become negotiable. But truth is not negotiable. A courtroom may be patient. A judge may listen. Procedure may give every person their chance to speak. But when the evidence is clear, performance ends. Karen walked in demanding 12 strangers to hear her story. Instead, one courtroom watched her own words destroy it. And Robert Hayes walked out with something more important than a judgment. He walked out knowing his work, his time, and his honesty had finally been respected. That is the lesson I carried from that day. Rights matter, procedure matters, the Constitution matters. But none of those things exist to protect a lie from consequences. Karen demanded a jury because she wanted drama. The evidence demanded judgment. And in my courtroom, evidence won